If fathers today, you take the children you have been told to be yours for DNA testing, how many of them are your own biological children? That is why the law, if you walk in and tell the judge, give me the order for me to do DNA tests over my children, the judges will refuse. The judges will ask you, were you married? Yes. Were those children born in a marriage? Yes. Then you are the father. Parliament has failed us. There is no law dealing with the DNA. But the courts have said they cannot be cowed. The courts have stood firm that they will continue ordering DNA testing in children matters, for maintenance and custody, in succession matters. The courts have been bold. Welcome to Court Helicopter Explainer. Today, we are not dealing with the issue of people who are alive. We are dealing with this question, what happens when you are dead? That's a very controversial issue. But also in it, we are asking, what happens on two issues? Has any woman said you are the father of this child? Has somebody just gotten mad and said you are the father of this child? Have you disputed paternity? Can somebody walk all over in town and say, this is your child? Look at his nostrils. Look at his ears. Look at his head. Look at her legs. Look at her smile. Look at earlids. This is the child of so and so. When such controversy arises, what happens? In children maintenance matters, the question at the center is about whether this is the biological child. It is a very hot issue. In death, when the person dies, people come and say, he was my father. She was my mother. But he never acknowledged me. There is no birth certificate. There is nothing. How will the succession court deal with this question? Here is a woman who has said, these children belong to the deceased. The deceased has been buried. A critical question is, this person are called objectors. They come under Section 26 for reasonable provision under the law of succession because they are dependent under Section 29. We dealt with that question. They are saying this man is our father. He died. There are no evidence. People come and say, no, we know he's the father. He introduced me, these children to me. Or there is nobody who is saying, this is not the father. So the question that we are dealing with, and this is the question that went before Justice Nyakundi. Justice Nyakundi at Eldoret in the succession cause number 194 of 1995. That is in the matter of the estate of Kibiego Kogo Chepkwony and Edna Chepkoech Tanui, the applicant, versus Veronica Chisuge Chepkwony. What did Justice Reuben Nyakundi decide over those issues? This is a judgment of Justice Nyakundi dated on the 3rd day of August this week. It was a serious issue. So, in this matter, the judge is saying what do I do? These people say you either exhume the body so that we do a scientific approach towards a DNA testing to be done, or let us do DNA testing with the wife who is there now with his children. This was the issue. That either DNA testing to be done with other children who are known to belong to the father, and these strangers who have come now, so that the DNA testing will comply whether they are siblings, or the judge to order for exhumation for that DNA to be done. People will feel so mad if the court says a body to be exhumed for DNA samples to be taken. Can you imagine your father who died 10 years ago being exhumed now for DNA tests to be done? The law, unless there's a crime that was committed and he was murdered and the DCI has discovered, that one, the DCI goes to court, gets an order to exhume the body. But here are his, in quotes, his children, his, in quotes, his wife, saying, let us exhume this person. The judge, Nyakundi, refused to exhume the body. But Nyakundi also realized there is no law for DNA testing. That is the greatest shocker in this decision. The judge says there is no law. In paragraph 34, the judge said, if there is no law, what then do we do? But I've got to order for DNA testing. So the question that is there any basis for a DNA testing? Can you refuse to do DNA testing? Yes, people have raised that question. In the judge's issue is paragraph 30. When the court speaks of presumption of legitimacy, it means that he is the father whom the marriage indicates to be so. Traditionally, both under customary and common law, where husband and wife cohabited together and no evidence of impotence was forthcoming from any of the couples, and the child begotten during that cohabitation is conclusively presumed to be legitimate, notwithstanding that the wife might have known to have extramarital affairs. The judge is saying there is always a presumption that any child born in a family, that child belongs to the father. Is that true? Sarah's told me this can cause war. If fathers today, you take the children you have been told to be yours for DNA testing, how many of them are your own biological children? That is why the law, if you walk in and tell the judge, give me the order for me to do DNA tests over my children, the judges will refuse. The judges will ask you, were you married? Yes. Were those children born in a marriage? Yes. Then you are the father. Because there is the legitimacy question that judges are reluctant to order. That is why they say that is indeed the presumption in our judicial underpinning that a child born within the marital relationship is legitimate without any question. So you can't be allowed. But now here is a child coming, not born in a marriage. what will the court do? Justice Nyakundi, in paragraph 32, said, DNA profiling being asked by the objector is provided for under Section 48 of the Evidence Act, which expressly states as follows. Section 48 of the Kenya Evidence Act covers the opinions of experts. It states that when a court needs an opinion on foreign law, science, art, handwriting, or fingerprint, the opinions of people who have special skill in those areas are allowed as evidence. These skilled people are called experts. The judge moves on in paragraph 34 to say, what we wonder is that when modern tools of adjudication are at hand, must the courts refuse to step out of their dogmas and insist upon the long route to be followed at the cost of misery to the litigants? The answer obviously has to be no. The courts are for doing justice by adjudicating rival claims and unearthing the truth, and not for following age-old practices and procedures when new, better methods are available. The judge, in paragraph 35, he said that an eminent necessity has arisen for this court to exercise discretion for a declaration that the DNA profile testing be undertaken by the government chemist in the alternative within 45 days of today's ruling. B, the DNA profile be within the cluster of alleged siblings or children of the deceased begotten with the respondent during the subsistence of this marriage. So the judge ordered DNA testing to be done. But the samples are going to be taken from the children of the known, who are known to belong to his children, to the deceased children. And the samples will be taken within and analyzed within 45 days. Have courts dealt with this matter? Yes. Justice Nyakundi provided for the principles that the courts use to give a DNA test. One is the best interest of the child. That if it is the best interest of the child, DNA will be ordered. Two, the threshold of proof. If there is also a question of proof and it cannot be proved by facts, then there must be an order. Three, succession limits. If, for example, somebody has been married and there are no samples, the court will order a DNA sample. Fourth, inherent discretion, that the courts can order scientific DNA testing if a bona fide, well-founded dispute of paternity exists rather than a speculative fishing expedition. Lastly, infringement of privacy. This is fun. Sarah's listened to this and got shocked. An adult's right to physical integrity and privacy may be justifiably be limited as provided under Article 24 of the Constitution to ascertain the truth in the administration of justice. Nyakundi looked at the following cases: MKK versus LGI in 2021, where the court stressed that DNA tests should not be ordered as a routine matter of course, setting the test of eminent need, where the child's welfare supersedes a parent's right against self-incrimination. There must be eminent need. In the second case, AWM versus LNG 2024, the judge says that, affirming that clearing confusion of identity serves the best interest of the minor. Let the DNA clear confusion. Third case, in re-estate of Bernard Njeru Kamau, the court says non-consenting adults or surviving relatives cannot be forcibly subjected to sibling DNA profiling to establish beneficiary status in inheritance disputes without exceptional circumstances. So the law allows for DNA testing. What are the lessons in this matter? Justice Nyakundi has admonished Parliament. Parliament to date has no law on how DNA samples, how DNA should be conducted. Murder trials depend on DNA. There is no law. Sexual offenses of rape, defilement, indecent touch depend on DNA samples. Manslaughter depends on DNA samples. Poisoning depends on DNA samples. The criminal law depends on DNA samples. The gun use, shooting of the gun, depends on DNA samples. Fingerprints on vehicle theft, on window breaking, on robbery, on burglary depends. Imagine, Parliament has failed. Parliament has failed us. There is no law dealing with the DNA. But the courts have said they cannot be cowed. The courts have stood firm that they will continue ordering DNA testing in children matters, for maintenance and custody, in succession matters. The courts have been bold. Okay, Dan and Omari, we thank Cyrus, Bramwell, and Vivian for getting this authority, but is thunder in terms of DNA sampling. Asante from Court Helicopter News.